Once again, welcome to the 2015 Orange County Community Conference. Today, our first session, we are going to be privileged to start out with avoiding common liability claims in community associations. Our guest presenter today will be Mr. Frank Ruggieri. Frank received a Bachelor's of Science degree in management from Florida State University with honors and attended the Walter F. George School of Law at Mercer University in 1995. Mr. Ruggieri was admitted to the Florida Bar in October of 1995. He is a member of the Florida Bar and a member of the Trial Lawyers and Real Property Probate and Trust Law sections of the Bar. Mr. Ruggieri has been practicing law in Central Florida for over 19 years and has devoted his practice to the representation of community associations since 1999. Frank has since been admitted to the practice before the United States District Court for the Middle District of Florida, as well as the 11th Circuit Court of Appeals. He concentrates his practice in the areas of community association, commercial and general corporate law. Also, Frank has prosecuted and defended covenant violations, collections, commercial and construction defect cases on behalf of the firm's community association and corporate clients. Mr. Ruggieri has been published in Condo Management magazines covering articles on collection and covenant violation litigation. He has likewise spoken on community association topics at CAI, which is the Community Associations Institute, events, and also a past member of the board of directors for CAI, the Mid-Florida chapter. Frank has also moderated prior Orange County homeowners forums. Mr. Ruggieri is certified by the Florida Department of Business and Professional Regulations to teach state-approved board member certification courses in the state of Florida. If you don't mind, please just go ahead and give a round of applause for Mr. Frank Ruggieri as he comes to present.
Excellent. Good morning, everybody. Antoine, thank you for that, for those kind words. I believe he took liberty to exaggerate as much as possible and to make me sound as good as as knowledgeable as possible. Well, good morning, everybody. Obviously, thanks for all of you for coming out. Been practicing law, as Antoine said, for about 21 years here in Central Florida, and I've done these programs before. I think that, I applaud the county for this program, what they do for community associations throughout Central Florida. It's a great thing, making these resources available to communities throughout Central Florida, helping them understand what deed-restricted communities are all about and what community associations are about and kind of the part that they play. I always have to kind of get used to the fact that I'm going to be in front of a camera with lights on me. I'll never forget the story that comes to mind is when Channel 6 many years ago came to interview me at my office, and then my brother contacted me shortly after the 6 o'clock news to make sure that I knew how bad I looked in HD. So, unfortunately, I believe this is going to be in HD as well. So, just hang in there, folks. Let's concentrate on the substance of the course as opposed to how good-looking I am or not good-looking. So, all right. Today's program: avoiding common liability claims in community associations. What's most important, I think, to understand as I get started on this presentation and when I was putting it together. Perhaps what's most important is to understand that there are really, as board members in community associations or homeowners in your community, there are really two kind of essential classes or categories of liability that you need to be concerned about. It's the liability of the association itself, the community association, and then also the liability or the potential liability that you could face as board members that are sitting on these boards for these community associations. So what you'll see as I go through the program, I've kind of divided it up into two general categories or classifications, if you will. I'm going to talk about association liability first, the liability of the association and how that works, versus the potential liability that board members can have in their community associations. And I certainly did not want to put this program together to scare anybody or anything like that. It's actually quite the opposite. What you'll see throughout the program is, you know what, folks, what it really comes down to is this. We all do things in our lives every day that can be dangerous. I guess the example that came to my mind is, none of us goes out into our backyard with a tank of gasoline and throws it onto the charcoal to start the fire to have a barbecue. We all exercise reasonable care in what we do on a daily basis and as we go about our lives. So what you'll see as I go through the program is really what it comes down to is, you know what, you act reasonably, you do kind of what you would expect to do in a particular circumstance, and there's kind of not too much to worry about. But at the same time, we need to be mindful as homeowners in our communities or members of our boards how these potential liability claims can come about and to be mindful of them. So let's go ahead and get started. And what I did too, what you will see, folks, as an attorney, as attorneys, we rely on what many of us hear maybe about in the news and things like that, the case precedent in the Supreme Court of the United States and cases like that. Well, those aren't just for lawyers, those are for all of us. That's what it's many attorneys will refer to it as the common law. It is the law that is developed through our court system at the trial level and then on appeal. And those appeal decisions, those appellate decisions are what sometimes we hear about. So as an attorney, to come to do a presentation like this, those cases really are, they're excellent sources, I think, for a conference like this because they're based on real facts. These are real facts, these are real board members, these are real communities that experience these cases. And it's like I said, these are actual fact patterns that happen that were litigated through our court system. They went to trial, they were appealed. So there are several cases that I'm going to refer to and talk about as we go through the program, and you'll see those. Okay, so getting started. Some of the basics of sitting on a board or serving on our board, some of the basics of community associations, responsibilities, and kind of how they run. Community association board members owe a fiduciary duty to the members. Now, what does that mean? How does that come about? A fiduciary duty is essentially, it's a duty of trust. And that comes about in certain ways, and typically what you'll see in many instances, this fiduciary duty or this obligation of trust comes about many times when you are entrusted with the property of someone else's property, their money or their property. When you are entrusted with that, this fiduciary obligation can arise, that duty of trust. Fiduciary duty is a legal obligation to act solely in another party's interests. So, as board members, as folks who administer these communities, you need to be mindful that those assessment monies, the dues that everybody has to pay to keep that association functioning, those are the funds of all of the individual homeowners in that community. Those are being entrusted to the individual board members. So that's where that fiduciary duty comes from, that duty of trust. And board members must certainly comply with existing state laws, okay? The most common for a guy like me, an attorney like me, the most common that you folks will see are two particular statutes. That's Chapter 718 for condominiums and Chapter 720 for homeowners associations. Those are the two most common statutes that exist in the state of Florida that govern and affect community associations and how they must be run. Board members must also comply with the governing documents for the community. Well, what are the governing documents? We've got the declaration. Many folks maybe refer to those as deed restrictions or the rules. I've heard it referred to as the bylaws. Well, the bylaws are actually one of the other documents. But that declaration, that's one of those documents that all board members have to comply with and stick to. We've got the Articles of Incorporation, the document that actually creates the community association. That's the document that's filed with the state of Florida that creates actually brings that corporation to life. We've got the bylaws. As I like to say, the bylaws are the kind of the procedural rules of the corporation. And then the duly adopted rules and regulations. If you are sitting on a board of directors, if you get elected to the board in your community, be mindful that within 90 days of being elected to the board, you must either sign something certifying that you will uphold the governing documents, that you've read them, that you're familiar with them, and that you agree to uphold them, or participate in a state-approved board member certification class, and one of those two must be done within 90 days of you being seated on that board. That educational certificate is valid for as long as you're a board member. So once again, these are kind of some of the basics. Board powers. Now, how does a community association, if we're going to talk about liability, how does that come about? Well, it's going to come primarily, we need to understand a little bit about how an association functions and what a board of directors has the authority to do. So a board has the power to contract on behalf of its members in the community to file suit, to sue someone, or be sued on behalf of the association. After a developer of a particular community turns control over to the homeowners, the board has the authority to represent all of those homeowners on matters of common interest. So whatever the common facilities are in the community, maybe we have a clubhouse in the community, golf course, something like that, facilities within the community, a stormwater management system. Okay, let's get into the first discussion or first area of liability that I wanted to get into after kind of covering some basics of board powers and functions in a community. Let's talk about premises liability. Well, what's premises liability? Premises liability is the liability that a landowner has for folks that are on your land. Now, a landowner can have liability to folks that are there, that are welcome there, that are invited, but you can also have liability to those that are there coincidentally. There's even cases where landowners have had liability with respect to someone who's on their property illegally. Now, that might surprise you. In law school, I studied what we all referred to as the spring gun cases. And kind of a scary concept, but there were some cases that discussed whether a homeowner could set a trap in their home for someone who's breaking in. And situations where that individual who broke in and was injured filed suit against the homeowner even though they were a burglar. Yes, there's liability there. So premises liability, the liability that a landowner can have for people being injured, things happening on your land because of the conditions that are on it. So as a community, one of the areas of liability we need to be concerned about is liability associated with the property itself. What if somebody comes onto the property and hurts themselves? So the first case that I wanted to talk a little bit about is a case from our Florida 4th District Court of Appeals. It's the case of Jank versus Corinthian Gardens. This is a situation where actually a guest of a unit owner in a condominium slipped and fell in the parking garage and filed suit against the association, claiming that the parking garage was excessively slippery and the association was not properly maintaining it. Now, what was interesting about this case, and the reason I wanted to bring it up and talk about this one specifically, is this one didn't really have to do with anything the association necessarily did. The plaintiff in this case was claiming that the surface of the parking garage, by its very nature, it was wet. It's simply, the theory of liability was that material that they used in the construction was just naturally slippery, wasn't suited for an open parking garage that was exposed to open weather. So this was nothing that the association did. There wasn't a crack in the sidewalk. There wasn't something that someone tripped over because the association did not maintain the area. This was simply the material that was used in constructing that parking garage. Now, what the court decided in this case, they said that the association was not liable. And what they said specifically, what the court said specifically in there was that the evidence in that case in connection with this slip and fall accident, the expert testimony that the deck covering was not slippery and performed reasonably well in various scientific tests and comparisons, and that was sufficient to support the jury's verdict that the association was not liable. So this was simply a situation where a guest of a homeowner was on the property, slipped and fell, and was saying, hey, you didn't do anything wrong necessarily in maintaining the area, but the area was just not suited and should have been changed. You should have done something different about the condition of the premises, the property that you folks own and are responsible to maintain. So, moving on from that. So that's, once again, one area to be concerned about is liability associated with the land itself, with the property, and maintaining the grounds themselves. Another area that we need to talk about, liability for association functions. Now, this is completely different. Unlike the situation where we had someone slipping and hurting themselves because they were claiming that the area was just excessively slippery and wasn't suited for it, in this particular situation, this was a direct claim of damage and a claim of negligence against this particular association, claiming that they did not maintain the area. Now, specifically what happened was this. We had some unit owners at this condominium that were experiencing excessive flooding in their units, okay? No matter what they did, the flooding wouldn't stop. And there was even some evidence that the developer in this case tried twice to seal the windows and do different things around the windows to try to prevent these leaks. Didn't work. So they filed suit against the developer and the association. So this was a specific claim that had to do with, or a theory, a claim that was saying, look, the association didn't do enough in maintaining what they're supposed to maintain, what they're obligated to maintain, and because of that, my property's been damaged, and I should be compensated for that, okay? Now, what's particularly, and the other thing that I like about this case is that what the court analyzed was the actions that the board took right after the homeowners were complaining about these leaks. Nothing ever got fixed. There's nothing in the evidence in this case that talked about the association actually fixing anything. So let's talk about that. This is what the board did. According to the evidence, the fact that the condominium association had been newly formed when the damage suffered by the unit owners came to its attention, the association referred the problem to its attorney, tried to work with the developer to resolve the construction defects, and within 4 months, authorized its attorney to file suit against the developer. So there was no evidence that the board actually fixed the leaks in this case. What the court analyzed was, how did the board react to that situation? What steps did they take to try to fix the problem? Okay? So the standard when we're talking about liability for what a community has to do on a day-to-day basis in operating that community, once again, going back to what I said about all of us acting reasonably on a day-to-day basis, there's only so many things that we can avoid as we walk around through our lives. Acting reasonably and doing what you can to address the situation is what the law expects of us as stewards of our communities, as board members. So based upon those factors, once again, pursuing the developer, actively going out and saying, hey, you did not construct these condominium units properly, it's your fault. They tried to get the developer to do something. They contacted their attorney. They were proactive with it. They were doing things to fix the problem. So, like I said, what was important in this case was how the board reacted to it, that they tried to address the issue and that they did not sit on their hands. They acted reasonably, okay? This next case, association as a provider of security. This is a particular issue that I wanted to bring up because I think it's something that many communities and many homeowners don't think about. can we as a community, as homeowners, can we face liability for not providing enough security? What if houses are being burglarized in the community? Cars are being broken into? What obligations does a board and a community have to provide security, to prevent things that are crimes, that are intentional acts that other people are committing? And unfortunately, there are situations when it can arise. This particular case is an extreme example. And I chose it to make a point about really what you'll see in the facts of this case is a complete disregard. A board that, for whatever reason in this particular situation, simply took its eye off the ball and wasn't really doing anything. And it's kind of an example by extreme, showing kind of how egregious things would have to be to kind of trigger some liability, especially for providing security. Because once again, we're talking about intentional acts that somebody might be committing as far as burglarizing a home or breaking into cars and things like that in your neighborhood. In this particular situation, very unfortunate set of facts. What we had in this particular case was a community that had gates. It had a security station where a guard would be a manned station at the front associated with these gates. It was not just a gated community. The developer developed this community with a guardhouse out front that was supposed to be manned. Okay? When the developer was engaging in sales early on in the development process, advertised the security associated with this. Hey, come by houses in Lago Grande. We have gates. We have manned security. Okay? So the developer was actively marketing and selling this community as gated, secured, manned security. Okay? Unfortunately, what happened was this. We had a unit owner in this particular community who had a friend. The friend had an ex-husband. The ex-husband was known to not be a very stable person. History of violence. They don't give you all of the facts in these appellate decisions. They don't give you all of them. But I think what happened, what I gleaned from this in reading the facts and what I think was happening, the friend was staying there at the condominium with the homeowner to stay away from the ex-husband. And they, in fact, advised the community, said, look, my friend is staying with me. Her ex-husband has a history of violence. He's exhibited violence toward her several times in the past. Please do not let him into the community. Okay? Those facts were communicated to this community with gates, with a manned security house at the entrance. The guardhouse was not manned. The gates were not manned, were not operating. And unfortunately, this gentleman walked right into the neighborhood, went directly to the condominium unit, and took the life of his ex-wife, injured her friend, and the family and the estate, whatnot, brought suit against the security company and the association. Okay? And the association was found partially liable for those damages that were associated with that. Okay? So unfortunately, there are situations where a community association can face liability in connection with its provision of security services. But what the court found in this particular case was the fact that this community was advertised as a gated, manned security type community. They were aware of these circumstances. The homeowner advised them of this, and they didn't have anybody up in that security gatehouse at all. It's an example of a community association essentially just dropping the ball, looking the other way, and really not acting reasonably. It kind of goes back to the example that I gave in the beginning of the presentation. We certainly, none of us would go out into our backyards to start a barbecue and take a can of gas and throw it on a stack of charcoal briquettes to start the fire. We don't do that. That's not acting reasonably, okay? There were numerous facts that were known to these folks. There were numerous circumstances leading up to this. So this is an example of how a community association can face liability in extreme circumstances in connection with its provision of security services. Okay. Individual board member liability. Before I get into this, into the individual board member liability, does anybody have any questions on what I've covered thus far? Okay, very good question. This gentleman up front asked some gated communities that are adjacent to where he lives or near where he lives, and he mentions that sometimes during the day they leave the gates open. Can they be liable? Once again, I mean, remember the facts of that case that I was talking about. We're talking about a very extreme set of circumstances. Not only was it a gated community, they had a guardhouse out front. They were not manning that guardhouse. They had specific knowledge. They were given facts that would lead them to believe that they should have been more careful than they were. So it's a difficult question to answer because there are a lot of circumstances surrounding why that gate's open. So for example, I've represented numerous communities that may have several children in the community that perhaps are physically challenged or whatnot, and we need to allow the buses to come into the community, and the community will leave the gates open in the morning to allow those buses to come in. Well, under those circumstances, certainly the community wouldn't be responsible if something happened. They're allowing that school bus into the neighborhood. So circumstances, why are they leaving the gates open? And then second, are there circumstances there, are there things happening that lead these folks to believe that they shouldn't be leaving the gates open? Are we having excessive burglaries and crimes happening right during that time of day when the association keeps leaving the gates open? That would be circumstances that might warrant something like that, some liability on the part of the association there. Yes, sir.
Your presentation, in particular, what you covered so far covers condominium association and mandatory homeowner associations. In case of volunteer homeowner associations, I hope you would just kind of in the context of that, and that you go through your presentation, anything applicable to those particular entities.
Absolutely. So this gentleman is asking with respect to voluntary associations, and what does he mean by that? I referenced Chapter 718 and 720. 718 being the Condominium Act, 720 being the Homeowners Association Act. Chapter 720 pertains to communities that are not condominiums, that have mandatory membership, that have lien rights. They must have those things to be a 720 Homeowners Association. So how does this presentation differ with respect to voluntary associations? It really doesn't. When it comes to liability, these are theories of liability that pertain to really any corporation almost. How could a corporation be held liable? These sorts of theories that I'm talking about can really pertain to any corporation. So they're really, these are issues that we need to be mindful of, whether the association is a mandatory membership association or one with voluntary membership. Yes, sir.
Yes, we are also a voluntary community. I was wondering if we have a green area or conservation area that borders our neighborhood, and I was wondering if there's any premises liability for that green area. It is not fenced. There's no signs indicating that they people cannot walk into this area. It is marshy. It is a little bit dangerous. Do we have any premises liability as a community? And the only thing I know is that this green area is owned by a corporation, somewhere in South Florida. That's all we know.
Yes, absolutely. So the gentleman's question pertains to an open green space area in the community and whether the association could face liability associated with that green space. And yes, he absolutely can under certain circumstances. So generally speaking, it goes back to the reasonable man standard, as I always say. And I'll give a kind of a brief background. So Ed probably should have covered this a little bit earlier on. Let's talk a little bit about what negligence is, okay? Negligence arises, you have to have 4 basic things in place to show negligence. There must be a legal duty. In other words, the law must recognize that you have an obligation under a particular circumstance, okay? So with respect to your question on open and green space areas, that legal duty arises because your community has an obligation to maintain that area. You collect assessments and you maintain that land. So your legal duty arises because you are the landowner and you have an obligation to maintain that area, okay? There must be a breach of that duty. You must have violated that duty and not satisfied that duty, okay? Third, you have to show that the violation of that, the breach of that, caused damage. There's causation between your act of negligence and this individual's damages that they suffered, okay? And then number 4, you actually have to prove that you were damaged. So taking those 4 basic elements of negligence, let's apply that to your question, to your scenario. So we've got an open green space area in the community. And once again, going back to my extreme example of starting the barbecue fire with a can of gas, which is something none of us would do, it's the reasonable man standard. So you are the landowner. You are maintaining this open green space area. You must act reasonably. What would a reasonable person do under the circumstances to keep that area reasonably safe? Now, you mentioned that the area is marshy, it's wet, things like that. There's probably a lot of circumstances about that area that you really can't prevent that. Maybe it's a low-lying area, maybe it's near a conservation easement, something like that, where it's always going to be wet and muddy. Nothing you can really do about that. Matter of fact, the state of Florida probably wouldn't let you touch that area if it is a conservation area, okay? So what would a reasonable person do to maintain that area? Other than the regular mowing that the state allows you to do. Probably not much else that you can do there. Some people have to exercise reasonable care for themselves too. You can't just go stepping into holes and acting unreasonably and negligently yourself and then claim that it's someone else's fault. So we all have an obligation to also look out for ourselves too. So difficult question to answer because I would want to maybe know a little bit more details about that area, but I put it to you this way. I always go back to that reasonable man standard. What would a reasonable person do under the circumstances? And what's reasonable to expect you folks to do? What's obviously, you can't chain off the area and put a fence around it and things like that. Probably not something reasonable that you can do. So, yes, sir.
Can a non-mandatory association lien for code violations?
No. And neither can a homeowners association. That particular question pertaining to code enforcement fines, the most important thing to understand there is that fine that was imposed is not money that's owed to the association. It's something that the county imposes. And so under those circumstances.
Codes and covenants of the association.
Oh, of the association?
Yes,
no,
sir.
you cannot. That's really, it pertains to your documents and what your documents say about that, but most likely, if it's a voluntary association, you will not be able to impose a lien for those violations, for the violations of the use restrictions for your community. Any other questions on general association liability before we move on into individual board member liability? Okay. Oh, yes, ma'am.
The security case with the 9% was liable for the association, right? I saw where the security company was most to blame, but 9% for the association. So in that case, would the officer and director liability insurance cover that? And what if it was over the limit? Would they do a special assessment?
Okay. So this woman's question up front pertains to coverage. It pertains to insurance. She asked whether, in the case that I talked about with the security, she noted in the discussion of the opinion that there were multiple defendants in that case. There was the security company, there was the homeowners association, and one or two others. I cannot remember the name of them off the top of my head, but different entities that were involved in security and maintenance in the community. And the jury assessed liability largely on the security company, a small portion to the homeowners association. It was only 1%. Now, I did not mention that, but obviously that's also an important point, folks. Recall the facts of that case, and as egregious as the facts were, with the association not manning the gate, they were still only found about 1% liable, and the security company who wasn't doing their job was held, mostly liable for that. So, insurance, does the directors and officers policy cover that? The insurance, does it cover that? Most importantly, that particular case, the plaintiff was bringing the case, they were filing the lawsuit against the association. So there was nothing about that case that indicated that they were actually suing the individual board members. If they had brought a claim against those individual board members, that's where the directors and officers coverage would kick in. It kicks in when we're talking about the liability of the individual directors and officers for malfeasance or breach of fiduciary duty. Would it cover it? Yes, if there were some indication that the individual board members were negligent there and that claim was brought, yes, it would. It would cover that. And that's exactly what that D&O policy or directors and officers policy is meant for, is to protect and provide insurance coverage for those individual board members. Now, another part of her question was, what if it was covered by that directors and officers policy, but the damages that were awarded exceeded the policy limits? What would happen then? Well, when you get insurance, any one of us, whether it's your car insurance, your homeowner's insurance, or whatever kind of insurance we're talking about, if there are damages assessed against you in a lawsuit or whatnot, and those damages exceed what your coverage is, they're now coming after you and your personal assets for that. Now, when we're talking about exceeding coverage for a homeowners association and individual board members, understand that the corporation has a duty to indemnify or protect the board members. So in a situation like that, unless those board members were absent extreme circumstances, the association would really have an obligation to protect those board members and provide indemnification, protect them from liability and cover that difference, essentially. But the most direct answer to your question is that if it's not covered by insurance, if you've got a claim like that, you've got damages that were awarded that exceed the coverage, it's now that corporation or that individual's assets that are now exposed and have to answer for that difference. So that's what can happen there. Now, excellent question because it kind of segues me into the next, but I did see your hand go up. Yes, ma'am.
We're a condominium. We have a unit that is rented, and the tenant, the police have been out there twice in the past 6 months for battery-type issues. Do we have a right and/or an obligation to notify the management company of that unit that we do not want the lease renewed?
Very excellent. This is an excellent question. Okay. So now, and folks, let me say, I have to say, as an attorney, I've certainly read countless fiction novels and watched many, many movies in my life, just like all of us have. And I can say without a doubt as an attorney that life does not imitate art. I think it's the other way around. That you cannot come up with more complex and nuanced fact patterns than what we have in our everyday lives. So her question was, we have a problem tenant who's shown some issues with battery and being violent towards other individuals. And this is a tenant. This is a renter in a condominium. So her question is, what obligation do we have as a condominium association to contact the management company that manages that unit, that manages that rental, to say, hey, this individual you have renting here has exhibited violence towards others, has a history of battery. What exposure or liability could that condominium have if this individual hurt someone and they never said anything about it? There certainly could arguably be some liability there, and I think it kind of goes back to that case that I talked about. It's what are you folks seeing? How persistent is it? Is it happening repeatedly again and again and again? As if I were your attorney, I would probably certainly recommend that the board do something about that. I do not like the idea of a community association or a condominium association seeing a situation like that where we've got an extreme problem tenant or homeowner and simply not taking any action at all. That's not a good thing to do. Now, let's say your community did do something, but it was simple as sending a demand letter. You sent a demand letter to the homeowner saying, your tenant's a problem, don't renew the lease, or get them out of here, evict them now. Would that maybe satisfy your obligation and protect the association from some sort of liability if something were to happen? Goes back to the other case that I talked about with the leaking windows, where that's all that board did was they did not fix those windows, but the evidence was that they had taken action. They had contacted their attorney. They had started pursuing the developer. They filed a lawsuit against the developer. So they were active. They were doing things. So in a situation like that, I think the best way for me to answer your question is I do not like the idea of doing nothing. But the association is not a guarantor of homeowner safety. Absolutely not. And if there were something, God forbid, bad to come about of that, if this individual were to hurt someone, I think if we have taken some action to do something, then I think we're okay. Okay. All right. Individual board member liability. This is when I teach board member certification classes. Yes, sir.
Our whole condominium association recently had one of its owners arrested and in jail waiting for trial for child pornography. What is the board's responsibility if he is convicted? What is the board's responsibility to the association and any future owners and future renters that come into that association?
If we have an individual in this gentleman's community who has been charged with child pornography, and the question is if he is convicted, say the last part of your question one more time. I'm sorry.
What would be the board of directors' responsibility to the association members and any presently and any future owners and future renters that come in there?
Well, I want to make sure I understand your question, because I'm assuming if the gentleman is convicted of what he's been charged of, he's not going to be in your community. He's going to be in jail. So I'm not sure what the concern would be as far as future actions. And if he is a property owner, are we concerned about him? Is the concern about him coming back into the community after he's released? Is that what it is? Yes. I got you. Okay. Yeah, these security issues, and it's why I wanted to bring it up, because these security issues are so peculiar and they're so nuanced. Many communities don't even think about it or realize that they can have any liability for security type issues like that. We've got an individual that's committing an intentional act here, folks. Okay, let's understand that. It's a crime. It's an intentional act. The law does not expect us to keep it from happening. Certainly, if you could, I would hope that we would do something about that. But in that situation, I don't see that there would be a significant concern on my part if you were an attorney that you would have to go out and broadcast that this individual may at some point in the future come back into the community. It kind of goes to this woman's question a little bit. At the same time, I don't like the idea of doing nothing.
But he comes back, let's say he serves his time, he gets probation or whatever. He comes back, next thing you know, he's molested a child, one of the children in the community. what reliability would we then have?
Potentially, certainly, I suppose there could be a determination that you folks did not act reasonably there. But once again, these situations where we've got crimes being committed, the law does not expect us to prevent it from happening. You can't. How do you know as we sit here that this individual might come back in the future? To me, it's extremely speculative. If you knew that he had been released and would be coming back into the community and the association did nothing about it, I suppose there's a possibility, yes, you could face some exposure there. If you did absolutely nothing about it, you knew he was coming back. The problem is that that's also public record. There's public avenues for people to find out about that. That's going to be on the internet and things like that, available through certain law enforcement websites where we can find out about those things. So I suppose there would be a moderate or very minor concern on my part if I were your attorney, but it's extremely minor. Okay, individual board member liability, and I've seen the hands go up a couple of times on time left, so I'm going to kind of try to move through this fairly quickly. Fundamental principle of corporate law is that a director must direct. The board is responsible for making policy and for ensuring overall supervision of the association. Very broadly, I want to kind of summarize this now before I get into some detailed examples and cases. Generally speaking, as a board member, you will not face individual personal liability. Like I said, let's differentiate between the association being liable and an individual board member facing individual liability. Two very different circumstances, okay? So, individual board member liability really is only going to be triggered in fairly narrow circumstances, and that is going to be if you are committing a crime, doing something that benefits yourself financially to the detriment of the association, or acting with complete willful and wanton disregard. Just a complete disregard for safety. That's really the only circumstances where an individual could possibly face liability for serving on the board. And that would be, to this gentleman's earlier question, once again, certainly there's no differentiation there between a voluntary association and a mandatory association. It's simply the act of being a director and sitting on that board. Let's get into some of the two specific cases that I cited to. Now, what I wanted to start with here, as far as individual board member liability, very briefly, is what we call Florida's business judgment rule. There is a difference between facing liability for the decisions that you make and the actions that you take as a director versus the homeowners disagreeing with what you did, which is much more common, and saying, hey, that was a stupid decision or a bad decision, you shouldn't do it. So under what circumstances can your homeowners challenge the decisions that you make as a board member? Under Florida's business judgment rule, okay, what it effectively says is, and I'm quoting to what the Court of Appeal, part of their decision in this case, I'm quoting from the case, okay? We're a duly constituted community association board, upon reasonable investigation, in good faith, and with regard for the best interests of the community association and its members, exercises discretion within the scope of its authority under relevant statutes, covenants, and restrictions to select among means for discharging an obligation to maintain and repair common areas. Courts should defer to the board's authority and presumed expertise. So what does that mean? Very flowery language, Frank. What does that mean? Okay. Basically what the court is saying there, the business judgment rule is that a court of law is not going to substitute its own judgment for yours, provided your authority or your decision is based on what the statutes allow you to do, what your documents allow you to do. In other words, you've got the authority as a board member to do it. So generally speaking, courts are going to defer to what you do, and if they're not, if a homeowner were to challenge a decision that you make and say, hey, that was a bad decision, even if the judge disagrees with what you folks did as a board, it doesn't matter. That's not what the law says. The business judgment rule is we're going to defer to boards, allow them to make decisions. They're the ones that are, for lack of a better phrase, have their feet on the ground, or are within the circumstances and the facts. Let them make the decision and don't disturb that absent in an absolute abuse of discretion. So it's very difficult, in other words, for homeowners to challenge what you folks do and say, hey, that's a bad decision, and to have that decision legally challenged and changed. Very difficult because of Florida's business judgment rule, okay? Breach of fiduciary duty. Now we're getting into individual board member liability. And what I cited to here is a 5th District Court of Appeals case, and I always like to point that out, okay? And the reason I like to point that out is because the 5th District Court of Appeals is our appellate court for Orange County. They're located over in Daytona Beach, and they hear appeals from the trial courts in Orange and Seminole and Volusia, Brevard. So they're our appellate court, and for guys like me and down at the courthouse, when I go there, the judges are bound by what they say. They don't have a choice. This is the law. This is our law for our jurisdiction, okay? This particular case involved an investor in a condominium who owned several units and was renting them out, okay? These were investment units. The community, the condominium, was still under developer control. You'll see the defendant, or the appellee in the case, is a gentleman by the name of Bhagwan Asnani. He was an individual board member. There were several others, actually. Point being, the defendants in this case were the actual individual condominium board members. And the developer, the investor that owned these units, filed suit saying, you folks aren't maintaining the common elements, you're not maintaining the facilities and whatnot, and because of that, I have not been able to rent out these units that I own, and I've been damaged. I've lost all of that rental income because you folks aren't doing what you're supposed to do. But he didn't just go after the association. The investor went after the individual board members, okay? So the court said, it's well established in Florida that absent fraud, self-dealing, and betrayal of trust, directors of condominium associations are not personally liable for the decisions they make in their capacity as directors of condominium associations, okay? So once again, we're in a situation where you've got to establish fraud, commission of a crime, stealing money, taking money from the association. You own a landscape company, you're on the board, and you sign an egregious contract with your own company to pay your company twice what the market value is for those same landscaping services. That's breach of fiduciary duty. You're intentionally benefiting yourself financially and abusing your position. So, folks, I'm getting the hands raised up. I apologize. We've got to bring the program to an end. I am handling another section later on, the Ask a Lawyer program here in a little while, so I can, any lingering questions, I'd be happy to answer those over there. So thanks for coming, folks.